Welcome everyone to the VA Claims and Appeals Workshop. I'm Frank Olson, the Veterans Outreach Representative for Congresswoman Lauren Underwood, based out of the Crystal Lake office. I'm very excited to be here tonight to help moderate this discussion. First, I'll turn it over to Andrew Tangent, who is the Superintendent of the Lake County VAC, to present information on VA claims and appeals.
Thanks, Frank, and thanks, Congresswoman Underwood, for having me to speak today. As Frank mentioned, we are going to be talking about VA benefits, compensation, pension, and appeals. Next slide. So defining a veteran, first up, what is a veteran? A veteran under Title 38 USC is anyone who served in the United States Armed Forces, the Army, Navy, Air Force, Marine Corps, Coast Guard, Space Force, and a couple others. Who had a discharge other than dishonorable. Next slide, please. There are two major benefits programs. There's quite a few more that are underneath the VA umbrella, but today we're going to be talking about service-connected disability compensation and non-service-connected pension. Next slide. So what is service-connected disability compensation? So these are for injuries or diseases sustained while on active duty in the United States military. A disease that can be something that somebody has is something like one of the Agent Orange presumptives, or an injury might be a veteran who served in Iraq and Afghanistan who was injured by an IED blast and has traumatic brain injury or other type injury. These are compensatable from a 0% to 100% disability rating from the Department of Veterans Affairs. There are injuries that can be incurred in or aggravated based on duty, and they are for all veterans with release from discharge with conditions other than dishonorable. Next slide. A non-service connected pension, this is an injury or disease that occurred to a veteran after the military service and after the presumptive period for injuries and diseases that could occur during service, or is not one of the presumptive diseases as defined by Congress. In order to be considered for a non-service connected pension, the veteran must have served during a wartime service. Their household income must be below a certain threshold depending on their dependent status, and they must be totally and permanently disabled. Next slide. Many veterans that might be listening to this call have probably heard or have friends who have had to go through the VA appeals process. Prior to 2017 and really 2019, when the Appeals Modernization Act went into effect, appeals for wrongly denied benefits would take years. There are veterans probably on this call who had appeals that lasted for 10 to potentially 15 years. We have advocated and represented many clients who have fallen into this category. So improving the process and speeding up the appeals process was a hugely important thing that the VA did, and so we're going to talk through a little bit of that. Next slide, please. So the appeals process now, before a veteran would have to file a notice of disagreement, which would go to the regional office where they would review the claims file. Then they would submit the VA would submit to the veteran what's called a statement of the case, which would put all of the law that was used and the reasons for the decision. This process took anywhere between 3 and 7 years for the regional office to finalize and get to the veteran. Once the veteran received that, these packets were typically pages and pages, anywhere between 30 and 100 pages long, depending on what the conditions that were being appealed for were. And the veteran would only have 60 days to file a Form 9. Many veterans actually missed this deadline, which is something that we advocates fought hard to change. So under the Appeals Modernization Act, there are 3 new lanes that a veteran can utilize. The first lane is a supplemental claim. If the veteran filed a claim and the VA said there was not sufficient evidence to support a finding for the veteran could, through themselves or their advocate, submit new and relevant evidence which would reopen the claim. Another avenue is a higher level review, where a high level individual, a decision review officer at one of the regional offices that handle this, review the claims file. No new evidence is allowed to be submitted, but it's all only based off of the evidence of record. And then finally was a notice of disagreement directly to the Board of Veterans Appeals, and this itself had 3 new lanes. One, a direct appeal to the board where no new evidence could be submitted, an evidence submission lane where a veteran could submit new evidence, and a hearing lane where a veteran could request a hearing in front of a Board of Veterans Appeals law judge. Each one of these maintain the effective date as long as they are filed within a year of the most recent decision. So, for example, if you filed an intent to file today, and then you were denied in 5 months, or you filed a claim in 5 months, and 5 months after that you were denied for that, but then within 6 months after that you filed a supplemental claim, your effective date would still be today's date. Same with a higher level review that was filed or a notice of disagreement to the board. If your supplemental claim is denied after you file it, for example, you still have a year after that decision to keep your effective date of today. Same with a higher level review. Now, once it goes to the board, if it's denied, you can actually keep the effective date open. If, for example, you do a direct file review by a board judge, you can file a supplemental claim after that decision has come out to keep your claim open and effective. Next slide, please. So the appellate landscape in the VA is the initial claim is submitted at the local VA office. If it is denied and you go through one of the new lanes, it would then go to the Board of Veterans Appeals. After it goes to the Board of Veterans Appeals, it ceases being under the VA's umbrella and then goes to the appellate courts in the United States, first to the Court of Appeals for Veterans Claims, and then after that to the U.S. Court of Appeals for the Federal Circuit, and finally ending at the Supreme Court of the United States. At any point, these cases can be remanded to a lower level for reevaluation and readjudication based off what the reviewers or the judges or justices see in the file. So this is the appellate landscape for all VA appeals. Next slide. Any questions?
Thank you so much for that presentation, Andrew. I know that would be helpful to everyone watching. Next, let's talk through some of the questions that Congresswoman Underwood's office received about VA claims and appeals. First, we have Zolt from Batavia, who wrote into our office asking about how to go about registering for medical benefits. Would you please elaborate on this process?
Yeah, so there's a couple ways to get medical benefits from the VA. The first is if you are below a certain income level, you can file what's called a 1010EZ form. Any service officer with any of the VACs in the state can help a veteran fill this form out. That then goes to the VA for whichever VA hospital is closest to you, where it's reviewed, and then a letter is sent saying that you have met the requirements for healthcare. You can also go to the VA hospital yourself and go to their patient registration office and fill out the forms there with a VA employee. For certain categories of veterans, the VA divides each veteran up into 8 different categories. There are some veterans who automatically get healthcare based off of their service. For example, if you served in Iraq or Afghanistan and you exit the military service, you automatically, from the date you leave service, have 5 years of healthcare from the VA. If you are a Vietnam veteran, for example, you have healthcare provided to you from the VA because of the possibility of Agent Orange presumptives. If you're a Purple Heart recipient or a Medal of Honor recipient, you also receive healthcare from the VA. So there's quite a few avenues that you can get medical care without anything else done, based just off of your service and your income. Now, if you are service connected for certain conditions, you also get healthcare. So if you are service connected, for example, at 0%, you can get certain healthcare conditions taken care of at the VA.
Great. Thanks, Andrew. Our next question is from James, who's from Naperville. James was wondering whether there are student loan forgiveness programs for veterans. Would you please provide some information on this matter?
Yeah, so currently under the federal law, a veteran who has been rated permanent and total by the Department of Veterans Affairs, so that means 100% permanent and total with no belief in the VA that there will be improvement from the symptoms, automatically qualifies for student loan forgiveness. There are other programs out there that you can work. For example, if you go to school and you get your education, and you have specific type of loans, and you work for the VA, or if you work in a low-income area for education purposes, for students in a low-income area, or an area where they're like a military base also qualifies working on in their school system. Or if you work for the state of Illinois, there's specific programs in which you can have student loan forgiveness as well.
Great. Our next question is from David, who's from Crystal Lake. He served on active duty in the U.S. Air Force for 27 years and applied for VA eligibility. He was informed that his retirement income was in excess of the means testing limitation. He wants to know, what is the means testing upper limit?
So this is based off of your geographical area. So it might be higher in an area like in a Naperville or Crystal Lake area than it would be in downstate Illinois. It's based off of the median poverty level for the entire area. So most likely David falls into category 8 of the categories that we talked about earlier. Now, that doesn't mean that he can never get VA healthcare. Actually, the potential exists that he might have some service connectable injuries that occurred to him in his 27-year career in the Air Force that can a qualified VSO can look through his medical record and evaluate and talk with David and his spouse about filing certain claims for him to be able to get him into that healthcare. So just because there is an upper limit does not mean that he's precluded from trying to get healthcare through another avenue.
Great. Our next question is from John, who was in the Army in the late 1960s and received an honorable discharge, but never used his home mortgage benefits. Are home mortgage benefits still available for him?
Yes, home mortgage benefits are still available for him. It is not something that has a clock on it that you have to use it in a certain amount of time, like previous iterations of the GI Bill, the education benefits did. So home mortgage benefits are still available to John.
That's great to hear. Our next question here is from Kenneth, who's from Woodstock. He was a member of the National Guard from 1971 through 1977, based out of the Madison Street Armory in Chicago. He did 6 months of regular Army training at Fort Polk, Louisiana. He received his honorable discharge in 1977 as an E5. He did not see any offshore combat. Does he qualify for any type of veteran benefits?
So it depends. So first and foremost, he was part of the Illinois National Guard from 1971 to 1977, which means he was most likely under Title 32 orders for every single one of his weekends, his training evolutions, all of those things. If he was activated, if there was a flood in the state of Illinois that he responded to, or any type of activation, he was most likely on Title 32 orders. However, if he was on Title 10 orders, which are federal government orders, and he was injured or had anything happen to him during that time, he could be eligible for benefits from the VA for compensation or pension benefits. Also, he may actually have had what's called a line of duty injury while he was on a drill weekend. That could also open him up to a lot of the benefits that the VA has. The best advice that I can give for Kenneth is for him to meet with a qualified veteran service officer and to review his military records and to look through his service treatment record, his service record, and see if there's anything in there that might allow for him to receive benefits.
Great. Our next question is from Lawrence from Montgomery, who's been covered by employer benefits throughout his career. He's retiring soon and would like to know if he's able to get VA health benefits assistance now and what steps he'll need to take in order to begin receiving them. He served in the United States Navy from 1978 to 1984.
So this goes to the question that was asked earlier from the woman in Batavia. So what he would need to do is he could go to the VA himself, meet with a VA employee to fill out the paperwork and see if he meets the eligibility thresholds, or he could work with a veteran service officer. Actually, if he's in Montgomery, depending on where he is, the Kendall County Veterans Assistance Commission is not too far from there. Or if he is on the Kane County side of Montgomery, he could go to the Kane County Veterans Assistance Commission, which has staffers that know what they're doing and would be able to help him navigate that process.
Great. Our next question, a constituent writes, what benefits am I entitled to if I served as inactive reserve?
So as far as inactive reserve, that individual would probably not be eligible for benefits, but there's always a but there. There could be something available for that veteran who served in the inactive ready reserve. If he was ever activated or she was ever activated under Title 10 or there was a line of duty during any training, the possibility exists, but usually if you're inactive ready reserve, you are not actually spending time in uniform as a National Guard or a regular reservist. You're usually not activated on Title 10 orders, but over the last 20 years of war, we have seen quite a few inactive ready reserve members be called up to serve on active duty in Iraq or Afghanistan or both, or some other area where they might have been called up. So just because they were designated as inactive ready reserve does not mean that if their situation met certain requirements, they would not be eligible for benefits.
All right. And our last question today comes from Thomas from Crystal Lake, who says, I'm a disabled Marine veteran. I applied for Agent Orange hypothyroid disability benefits. I took the required exams and was notified that my claim is deferred without any explanation. It's been almost 7 months since I applied, but I can't get help from anyone at the VA. Thomas would like to know what the next steps are.
Yeah, so when you file for benefits, there are three things that happen on an initial claim. First, the claim is granted, and that's pretty self-explanatory. Second, the claim is denied. Again, that's pretty self-explanatory. And the third is deferred. And the VA can defer conditions for numerous reasons. First and foremost, if you went to a compensation and pension exam, as Thomas said that he did, and the provider did not provide a good enough opinion, they would defer the claim, asking for a better opinion from a different provider. If the provider failed to consider pertinent medical evidence, that could be a cause for deferral. Or in the case of Thomas with hypothyroidism, if the federal law changes. So from the fact pattern, it looks like he filed his claim at least 7 months ago before it was deferred. Unfortunately, the National Defense Authorization Act, which added hypothyroidism to the presumptive list, only went into effect beginning of this year. What the VA has to do is they have to, when there's a change in the law, they have to file with the Federal Register the changes to their procedures and their policies and their regulations. So just because the law changes doesn't necessarily mean that the VA is automatically going to start granting these conditions as soon as the law changes. They have to go through a process just like a government agency, and they are in their final stages of putting this all together and getting everything approved so that their internal adjudication manuals are updated and that all of their literature, their regulations are updated. And this actually, Thomas is not alone in this. There are quite a few veterans who have filed for the 3 new presumptives: bladder cancer, hypothyroidism, and Parkinson's-like symptoms. They've all been deferred because the VA is waiting on guidance on how to adjudicate these. But once that is finished, I believe the public comment portion of the regulation being posted on the Federal Register is closed. so that it should be very soon. So if Thomas has completed everything, it should be not that much longer before he gets a decision on that.
All right, great. Well, so this concludes our event. I want to thank you for joining us today, and thank you to Superintendent Andrew Tangent for all the information and resources. If you have a question regarding your VA claim or appeal for Andrew and the staff of the Lake County VAC, their number is 847-377-3344, or you can visit them online at www.vaclc.org. I'd also like to note that the Veterans Benefits Administration, or VBA, Chicago Regional Office is open and operating under normal hours, Monday through Friday from 8 a.m. to 4 p.m. Visitors seeking assistance at the Chicago Regional Office are encouraged to schedule an appointment on the Visitor Engagement and Reporting application, which is a self-service portal that allows visitors to schedule, reschedule, and cancel in-person appointments. The ability to request a virtual appointment is coming soon. Please follow the link to schedule an appointment. And if you have any questions for Representative Underwood's office, please do not hesitate to contact our office at underwood.house.gov or call 630-549-2190. Thank you, everyone, and please stay safe.